Good morning. I am Paula Hoffman, a juror, in the case of the plaintiff, Christina, whom has filed a suit against Ashford Hospital. Defending the hospital would be Shante Bullard. The allegations are from the plaintiff, Christina, that improper release of her personal health information without her consent to do so. I would have to agree with Christina. She never signed or gave a verbal for her information to be viewed by said person or persons. This is known as a HIPAA violation, which is a law that stands for Health Insurance Portability and Accountable Act. This came into effect in 1996. Its sole purpose is to protect a patient's medical record and any other pertinent information such as health plans, which could be provided to doctors, hospitals, and any other healthcare providers. HIPAA is a privacy act. In the plaintiff's case, she gave consent for the medical team to have access to her records, although no consent was given for any other personnel to review her record. The defendants took it upon themselves to obtain access. There are two situations a PHI would have a record disclosed. One of being the individual themselves and his or her representative, and two, through HHS, known as Health and Human Services, due to a compliance investigation. And neither of these were the subject of the matter. As stated before, the employee has been a victim of a violation of her privacy. And yes, if HIPAA is breached, it can result in fines, loss of employment, and possible jail time. The HIPAA Privacy Act allows the patient to have some form of control over his or her health. When disclosing a person's PHI, it is unethical for the involved party to do so without consent. As a medical care provider and team, we all take an oath, and to view someone's PHI without consent is an oath that, to me, has been broken. The plaintiff also stated she feared her record would cause her to a possible employment loss or coworkers thinking she is incompetent as a worker, which can open up another chapter in this scenario. This, to me, is a costly teaching example in which all organizations need to enforce the Privacy and Security Act. There is always room for improvement within a facility, and everyone needs to be on the same page per se and practice HIPAA every day. And if one is aware and unsure of how HIPAA is instituted 100%, then they should go ask someone that is higher than them, such as maybe a director. As for the email, no one needed to have the information but the team that was performing the medical procedure. With emailing the paperwork, there is more risk of it getting into the hands of another person. Best route is possibly faxing due to security purposes. As stated previously, an employee should not have to fear whether their PHI will be used against them. That is a form of job discrimination, which can lead to other legal factors. If the supervisor shared health info with other employees, that is a violation, a HIPAA violation. HIPAA protects from the unauthorization, use, or disclosure of any PHI. The HIPAA privacy law applies to covered entities, which are, number one, health plans, number two, healthcare clearinghouses, which, for example, is a public or private entity. An example of that would be, say, a billing service, repricing company, community health management info system, or community health info system. The third example would be such as healthcare providers who transmit any health information in electronic form. The privacy rule applies to employers if they have those three covered entities as stated before. In this case, I would say since the PHI was transmitted in electronic form, such as email, that the PHI is a covered entity. But for me, the final thing I still have going through my mind is the patient consent. It was not given for anyone but the medical team to view her PHI. So therefore, I still feel like she was violated because it went against everything that HIPAA represents. So in closing, I feel as though I stated before that HIPAA was violated due to failure to obtain consent. And I feel as though the patient is a form of violation of the HIPAA Privacy Act. So therefore, I do feel as though the plaintiff should be rewarded or compensated in this suit. Thank you.
Mm-hmm.